First, discussion of the specified rules from the revised rules of criminal procedure in the Philippines. Rule 1110, prosecution of offense. These rules governs how criminal action are initiated and prosecuted. Criminal actions are generally initiated by filing a complaint or information. Complaint is a sworn writing statement charging a person with an offense subscribed by the offended party. And the public officer, another public officer, and the information is an accusation in writing and charging a person with an offense subscribed by the prosecutor and filed with the court. For example, in the crime of adultery and concubinage shall not be prosecuted except upon a complaint filed by the offended parties or spouse. And the crime seduction and abduction and acts of lasciviousness shall not be prosecuted except complaint filed by her parents, grandparents, or guardians. And to the Rule 111, the prosecution of civil action. This rule allows the simultaneous prosecution of the civil action, with a criminal action unless or otherwise provided by law. Civil liability arising from the offense is deemed instituted with a action unless offended party waives it. Reserve the right to file it separately or institutes it before filing the criminal action. And Rule 1112, preliminary investigation. Preliminary investigation are conducted by the prosecutors or authorized official ensuring due process. If the probable cause is found, the prosecutor files the information in the court. Required for the penalties of the in a penalty of imprisonment and 4 years and 2 months and 1 day. And all cases filed in the RTC must go on the preliminary investigation. And in the MTC, it depends in the penalty. If the penalty is at least 4 years and 2 months and 1 day, so it means it needs a preliminary investigation. If it's lower and 4 years, 2 months and 1 day, so no need to preliminary investigation. And the procedure of the preliminary investigation is filing a complaint o file ang offended party. Then action, and second is the action of the investigation officer. If you file a complaint or information in a complaint, it will be assigned in a investigating prosecutor. And then the complaint is investigating prosecutor. Then the investigating officer must read the complaint together with the evidence and what is the action, whether the case must be dismissed or whether the dismissal of the complaint, or the investigator officer must he will issue investigator officer will issue a subpoena to the respondent, and the respondent file a counter affidavits. Clarificatory hearing is number 4 is clarificatory hearing is an optional. Number 5 is the resolution of the investigating officer, or the resolution must be dismissed or must be in trial. So in trial, the information must be filed. And let's go to Rule 113. Rule 113, the arrest. The arrest may be made with or without a warrant. And there are two types of arrest. Search warrant, warrant of arrest, and warrantless arrest. Let's go to warrant of arrest. The warrant of arrest is due to due process. The proseso, evaluated by the judge. If there is a probable cause, so the judge must issue a warrant of arrest and give it into the arresting officer, police officer, and have 10 days to conduct or to enforce the warrant of arrest within the 10 days. If the 10 days over and the person not be arrested, so the arresting officer must return the warrant of arrest in the judge. Turn to the judge to and wait until if the judge must return the warrant with the police officer, and the warrant must be enforced by a law enforcement officer and a police officer. And during the enforcement of warrant of arrest, it must be no violence or unnecessary use of force, and also inform the accused the purpose of the arrest. And the second is the warrantless arrest. Warrantless arrest can only be conducted in cases in flagrante delicto, caught in the act. You see a person that making or during or after the criminal action. see the person making a criminal action, that is, you can arrest him in a warrantless arrest by flagrante delicto, caught in the act, and hot pursuit. You see a person that you have knowledge that this person is having or committing a crime, it must be a warrantless arrest. And when an escape is being apprehended, or escape a prisoner that escaped in a penal farm, that is the Rule 113 arrest. May substansa arrest. Ako, tigaghan na. And let's go to Rule 114 and the bail. Bail regulates the release of the accused on bail. Pagbayad, bayad ka, hindi na ka mo billable, and ensure their presence in court. In bail, all crimes, all criminal action is billable except of the except in the case of conviction of the offense that bail is a matter of right before the conviction for an offense not punishable by death or reclusion perpetua or life imprisonment when the evidence is strong. All person in a custody shall be admitted to bail as matter of right. Ano naman siya pwede makabail? Siya pwede makabail before and after the conviction by the RTC o IMTC, Municipal Trial Court, and before the conviction by the RTC of an offense not punishable by reclusion perpetua or death, life imprisonment. Pwede siya makabail, pwede siya mo-grant of bail. And why the actor Bong Navarro grant a bail? The crime of Navarro is rape punishable by reclusion perpetua. And why did Bong Navarro, the actor Bong Navarro, grant a bail? Because the evidence is not strong. So the actor Bong Navarro is grant the bail amount of 1 million. As a bail and Rule 114, bail is a matter of right. And now we go to Rule 115, right of the accused. The right of the accused, Rule 115, enumerates the constitutional and the statutory rights afforded to the accused during the criminal proceeding. Dito ganyan sa arrest. In the arrest, during the arrest, the accused must known the accused shall have the right. So during the arrest, we call Miranda rights, that reading in the accused to You have the right to remain silent. That rights that include the presumption of innocence, rights to have a counsel, right to be informed of the charges. If what is crime that the person committed, he have the right to know of his charges, and the right to speedy and impartial trial, public trial. And Rule 116, the arraignment and plea. The arraignment and plea provides the procedure for the arraignment and entering plea. So, where metabo ang arraignment and plea in the court. The arraignment is reading the complaint or information whether the accused pleads guilty or not guilty. If the accused is formally informed by the charges in open court and enters plea, if the person pleads not guilty, so must be go in. So if the accused refuses to plead or plea is not guilty is entered, plea is not guilty, so it's entered in by the court. And let's go to Rule 117, motion to quash. Allows the accused to challenge the validity of the complaint or information. And the grounds include lack of jurisdiction. The jurisdiction, lack of jurisdiction, improper venue, extinguishment of the offenses or penalty, all double jeopardy. Punitan ay example, you have murdered, you have commit a crime, murder in Barangay San Pablo, but in the information, the statement is telling that in case in San Pablo, in the information is in the other barangay in San Pedro. So the accused allows to challenge the validity ng motion to quash. And Rule 118, pre-trial. It shall be held within 30 days before the arraignment. So aims to simplify issue, consider plea bargaining. Ng plea bargaining, agreement. So siya in the plea bargaining, the charge is you attempt to say that if charge is murder, pwede pa mangyo ka nga makuan pa sa homicide, magbong pa sa homicide, maunang sa plea bargaining. And in the stipulation of facts, there is the agreement within the two parties, and the marking of the evidence, marking for the evidence, identification of the evidence. So to now the showing of the evidence, presenting the evidence, and waiver of the objection to admissibility of the evidence if the evidence is admissible. So, and the modification of the order of trial if the accused admit the charge but interpose of the interpose a lawful defense. The pre-trial is mandatory in criminal case. Mandatory in criminal case. The court may, not shall, but may consider stipulation of facts, admissible of the evidence, and scheduling. So, such as matter will promote a fair and expeditious trial of the criminal and civil aspect of the case. So, no delay, mas pinadali aron nga makuha dayon ang justice. Unang ilang gipadali bitaw nang walay aron dili na ma-delay. So may kalainan sa pre-trial o sa pre-trial and civil case. In pre-trial and civil case, it required, and in pre-trial civil case, it required the parties involved to submit a pre-trial brief. Dili tong brief nga suton. Ato a brief, pre-trial brief, document to submit to the court 5 days before the pre-trial. Document to submit 5 days before pre-trial. And that happens in the pre-trial civil case. Ito magbaylog mga dokumento, mga ebidensya, dili pareha sa pre-trial nga in criminal case. Di pareha sa pre-trial in criminal case. Kaya sa pre-trial civil case, magkuha na sila, need to submit documents. Dili na sila objection, dili na mag-inuana dito sa court, dili na sa ang ilan na lang, mag-submit na lang sila og documents, mag-submit sila do mga ebidensya, dili na kanang kung ano pa nang magdebate pa ang mga abogado. Dahil lahi ra ang sa civil case, mga dokumentary ra og mga ebidensya ang kinahanglan. So in Rule 199, the trial. In the trial, is governed to procedure for the trial phase. Trial mo na ni, sakop na ni. The trial must proceed with the prosecution presenting evidence. First, present the evidence is the prosecution, and followed by the defense. And follow the defense, and the accused may present evidence. The accused may present. Pwede na siya dili mo present. Dili pareha sa other side nga, kinahanglan yun sila mo present og evidence. Kay kinahanglan shall present, the prosecution shall present the evidence. While sa defense, may dili sila the accused may present, dili ingon nga kinahanglan jud mo present og evidence, and after mo present ang mga evidence both side, the prosecution rebut evidence, and the rebuttal and the case shall be deemed submitted for decision. Dito na daya magtagal og decision. The courts are required to ensure the expeditious proceeding and avoid delay. Pinaspasay gapon para makuha dayon ang hustisya. And in the Rule 121, new trial or reconsideration allows the court to correct errors in judgment or consider findings. Grounds for the new trial includes errors and prejudicial to the accused or newly discovered evidence. If the crime na natay bagong ebidensya, so maunang mo new trial or reconsideration. A motion for reconsideration may challenge the decision based on errors of fact or law. For example, a case of bigamy. Like, example, me, ang asawa ko nakoy asawa. Dayon, ang asawa ko lain, kasado mi ato niya. So, pailan ko kaso sa atong kasado, ay mapailan ko kaso sa kasado, sa pamilya niya, pailan ko kaso nga bigami. Then madokdukan, magilty. The court decision that guilty in the case of bigamy. Then, so, mo appeal in new trial or reconsideration for the new evidence. If nako ebidensya nga, ako din asawa sa una, patay na. So, pwede ko mo new trial or reconsideration. Pwede ko mo new trial or reconsideration. Okay, namatay mo akong asawa, pero nasa ka ng kuan before 7 years. So, mo to, pwede nga makakuan ko new trial sa ilang error nga judgment sa kaso nga bigamy. Okay? Hindi naman ko mga asawa na, kay patay naman na akong asawa. Na, sa bigamy. And should to Rule 126, search and seizure, provides the rules on obtaining and executing search warrant to protect the individuals from unreasonable searches. Sample ng search and seizure. Example, search warrant nyo kay aning balaya, ay shabu. Ay, for example, legal drugs. Then, nakita mo pusilya, inyuhang apilon. So, it depends upon the situation. If the firearms seized in a plain view, so the search is valid. If in the search warrant is the drugs, illegal drugs, but you get a firearms, so it's not valid. So if the search going on, you see firearms in a plain view, so the search is valid. And search warrant must be issued upon probable cause. Muna na, magikan niya po na sa court. Court mo issue if there is a probable cause. Then, supported by the oath of affirmation and particularly describe the place to be searched and the items to be seized. So, kung unsay gipangita nyo, mao ra gyud yung pangitaon nito. Ito, makita mo na ito lagi. Kita mo kuhan. So, if it's open in a plain view, makita sa plain view. Mabalid, yapon siya. Then, the warrantless searches are permitted in specific cases such as searches incident to a lawful arrest or consented searches. These rules are ensure fairness, due process, and efficiency in the administration of Criminal Justice in the Philippines. So, evening sir. Makikita kong pan sir, pero panikamutan ako sir. Ako ang pag-eskwela. Mato ako ng sabtan sir. Daghang salamat sir. Pan sir. Ngayong gabi, Merry Christmas sir. God bless.